when a judge of the Allahabad High Court was sought to be impeached, he resigned before the impeachment motion could go through. There was a second occasion in 1993 where the motion fell in the other house because of want of quorum itself. So before I deal with what the learned judge has presented before us, a few words about the kind of system which we have adopted in this country. We perhaps have adopted some of the soundest principles for running Indian democracy. We are a parliamentary democracy where different shades of opinion are represented. We have an independent judiciary. We have the concept of separation of powers. And this power of removal of a judge is given to the legislative body, a political sovereign, which conducts an inquiry in accordance with the Judges Inquiry Act, where there is a predominant participation of judges, and on their recommendations decides whether to remove a judge or not to remove a judge. So originally, when we devised the concept of independence of judiciary world over, we were conscious of the fact, the whole mankind was conscious of the fact, that to judge the fate of ordinary humans is normally a divine function. But we bestowed this power with an ordinary human being, in the hope that this ordinary human being would almost be perfect. He would be free from all collateral considerations. He'd have a high level of scholarship. He'll have the utmost integrity. And therefore, we were convinced that this function could be performed by the judiciary, and that itself would safeguard the rule of law and adjudicate fairly disputes between ordinary people. So as times have passed by, there are too many whispers and too many aberrations which we are confronted with. It's only a very rare case which comes to this house for consideration. And therefore, sir, we are now living in a changed time where the level of vigilance and the standards of probity will also have to be higher. The judges will also have to realize that judiciary is no longer an institution which lives on ivory towers. Judges, like most of us here and others holding constitutional offices or high offices, also now live in glass houses. And therefore, whether it is the public, or it's the media, or it's the litigant, or it's the bar, they eventually become the best judges of all judges. Their conduct also is going to be watched, and watched very closely. This is not to say that we can make unfounded allegations against a judge, because a judge in ordinary circumstances speaks only through his judgments. He is not able to defend himself. And therefore, we have to be very cautious about every word that we say, write, or speak, both inside and outside this house, that judges and the judiciary is an institution which can't be thrown to the wolves. It can't be made an object of unfounded allegations, but it will also, like other institutions, have to stand by the scrutiny of all times. When a judge, sir, is sought to be impeached through a procedure, what are really the standards we expect from the judge? Do we expect from the judge to resort to every technicality which is available to him? Do we expect the judge to say that I will not enter the box so that I cannot be questioned? There are hard facts which I will not be able to answer. Or do we expect a judge to be a role model as a litigant and then candidly state every question that is put to him? Because a system can't suffer a judge who is stigmatized. A judge who is stigmatized can really never be in a position to represent the face of the rule of law in India and be a judge as far as others in the society are concerned. Therefore, sir, when a judge says, I will not appear myself and answer the questions, or that first prove the allegation against me and let me see how much you have in your pocket against me. Only then I will let you know what my response is. That is not the case of an ideal judge facing an inquiry. It's been repeatedly said, and we hear this phrase, and rightly so these days, that holders of high offices must be above Caesar's, like Caesar's wife, they must be above suspicion. Caesar divorced his second wife because he suspected of an illicit relationship. Even though the charge was not fully proved, he went through a divorce because he said Caesar's wife, considering the position she is in, must be unsuspectable. So a judge really cannot say, first prove an allegation against me beyond reasonable doubt, and only then I will come up and tell you whether I have an answer to give or not. A judge by his very character must be unsuspectable. His position must be such that nobody can point a finger to him. We've heard, sir, the presentation of the learned judge at length. So I've had an opportunity to read the entire record which the Secretariat has served and distributed to the members. At times I got an impression whether the facts which I have read are similar to the facts which I was hearing from the learned judge. So when we were young lawyers, we were all trained that if in a given case you are strong on facts, you bang the facts first. If you are weak on facts but strong on law, you bang the law. And if you are weak on both, then you bang the desk. At least you'll appear to be confident. I was wondering what the facts are. The facts are in a very narrow compass. One doesn't have to go into a complicated circle of facts in order to determine that there are many other cases in the judiciary where people are accountable. Of course, there are other cases in the judiciary also where persons should be accountable. In the matter of probity or the lack of probity, there is no right of equality. There are other people who've committed offenses while being a judge and got away with it. Is no ground available to any judge to say that I must also get away with this offense. In the matter of violation of law, there is no Article 14. Article 14, the right to equality, applies in the matter of application of law, not in the matter of violation of law. And therefore, to discredit other judges and say, well, there are others like this and therefore I must get away, is never an argument available to any citizen, least of all to a judge. What are the facts, sir, as are apparent from the report of the inquiry committee and the entire record which the Secretariat has served? I heard large discussions about workmen being paid and all workmen have signed. I found that this case has nothing to do with any workman. The charge has nothing to do with the workman. The case in a nutshell is that Steel Authority of India, a public sector company, brought certain goods. The goods were to be brought through the shipping route by the Shipping Corporation of India. And there was a supplier, there was a dispute over those goods and its qualities. The Steel Authority of India moved the Calcutta High Court. And the Calcutta High Court in 1984, 30th April 1984, appointed the then Mr. Sumitra Sen, an advocate, as a receiver. The Calcutta High Court said, take charge of these goods. You can then make an inventory of the goods. Depending on the direction of the court, you can sell these goods. Mr. Sen takes charge of these goods and he keeps the goods in his custody. Nothing happens. There was a direction of the Calcutta High Court that what you do to these goods and the monies you recover, every 6 months, please file a return with the Calcutta High Court. From 1984 till 2006, 18 years, not once is a return filed. Nothing very seriously happened till 1993. On 20th January 1993, the Calcutta High Court says, what has happened to these goods? Please sell them. You are entitled as your fee 5% of whatever is the sale value. And whatever you sell, open a bank account, keep it in that bank account. and the court will decide what is to be done with this money. And the court says, don't create any encumbrances on this money or on the goods. You can't use it for any other purpose. Over a period of time, the goods are slowly sold. And finally, an approximate sum of rupees 33,22,800 is received against these goods. Goods are sold over a different period of time. Mr. Sen, as he then was, opens two bank accounts. Once in the ANZ Grindlays Bank and the other account in the Allahabad Bank. He deposits rupees 4,68,000 in Allahabad Bank and the balance about 28 lakhs in the ANZ Grindlays Bank, which later merged and became the Standard Chartered Bank. What does he do with these monies? Now, these monies are to be kept in these accounts. They will earn interest, and eventually whoever succeeds in the case will get these monies. So the money lying in the Allahabad Bank, what does he do? And that's the reason the Judges' Inquiry Committee said he claimed a right of silence. Obviously, his advocate couldn't come and answer. He only argued on law. If he had appeared and the inquiry committee had asked him these questions, how come this money which was lying in these accounts was for the benefit of the court? You are a receiver of the court and the court would give it to a winning party. He first cuts out checks from these accounts, gives 4 checks in the names of private individuals who are known to him, who have nothing to do with this case. One Subroto Mukherjee, Biresh Pratap Chaudhary, Somnath Ray, K.L. Yadav, one Jai Guru Enterprises gets that money. Other amounts of money, his Visa credit card bills are debited to it. There is a well-known law book publisher, SC Sarkar and Company. So law books purchased, the monies go from that account. While this was happening, and this was the entire rigmarole that the presentation was today getting into, another judge of the Calcutta High Court appoints him as a special officer in the case of one Calcutta Fans. That case had nothing to do with this case. He is paid 70 lakh rupees so that workmen of Calcutta Fans could be paid. He opens another bank account and puts this 70 lakhs there. Of this 70 lakhs, and that's where his behavior lies, of this 70 lakhs, he quietly withdraws 25 lakhs and makes a deposit in the name of one company, Links India. Obviously, this 25 lakhs has gone there. So the money is short for the workmen in the second case. The second case has nothing to do with this impeachment proceeding. When he is paying the workman and he realizes he is short of money, because Links India then goes into liquidation soon after he deposits the money. So what he does is, from the Steel Authority money which is lying in the other account, he removes 22 lakhs and deposits it in the Calcutta Fans case. As a result of which, only 800 rupees odd are left in this account. Well, this is a serious issue to ponder, which, sir, I'll deal with a little later. In February 2003, Steel Authority moves the court and said, we have not got any accounts. We have not got our money. What's happened to our money? This case is pending for over 18 years, 19 years. And the weakness of our system is, since judges appoint judges in this country, the government has a very marginal role. In December 2003, he is elevated as a judge. Now, the first thing that should have struck him when he becomes a judge, that I am a receiver in some cases, I have got somebody else's money. He has already misappropriated that money for some alternative purpose. He just keeps quiet and keeps sitting on it. So during his tenure as a judge from 2003 onwards, this misappropriation for the alternative purpose continues. When he doesn't answer the advocate of the Steel Authority of India, they move the Calcutta High Court. The Calcutta High Court issues notice to him repeatedly, Please file an affidavit and tell us by this time he's a judge. What have you done to this money?